Uh,
Yeah,
and you're good if I post this on YouTube, share with my class and all that?
wherever you want.
Awesome. Well, thank you so much. So yeah, we'll get right into it. I was just hoping maybe you could make us like introduce yourself, I guess, just kind of who you are, your background. Yeah.
Yep, I'm Kyla Lee. I'm a criminal defense lawyer in Vancouver, but my practice focuses mostly on driving offenses. So, impaired driving, prohibited driving, roadside prohibitions for alcohol and driving, and driving while prohibited, disputing prohibitions for points, traffic tickets, anything like that. If you can do it wrong in a car, I will deal with it. If there's no points
Awesome.
involved, I don't care.
Great. Awesome. Well, that's great to know. Yeah, so we're gonna be talking about the crash that happened at Thompson Rivers University last year, just outside. You made a brilliant TikTok video on it at my request back in November. It was. It was very informative. So yeah, I'm just gonna kind of go through some questions, and yeah, you can best answer them, I guess. Yeah. So the first question, kind of. Just maybe go over what you said in the video again. Like, can you explain why there's no criminal charges? Instead, we're looking at Provincial Motor Vehicle Act charges.
So, what happens when any accident takes place that police investigate is they look at the driving behavior to determine where on a spectrum of driving behavior it falls. In Canadian law, dangerous driving is where somebody's driving amounts to a marked departure from the driving of a reasonably prudent driver. So it's a relatively high standard. It has to be not just bad driving, but it has to be a marked departure beyond that. There's an even higher standard for criminal negligence in your driving that causes death or bodily harm, where you have to be like criminally negligent, which is even higher than a marked departure. And for careless driving, a motor vehicle act offense, it's momentary negligence. Often, when police arrive at the scene of accidents, they don't have the evidence necessary to prove that a criminal act caused the driving, whether there's, no witnesses because people were deceased or because it was a single vehicle accident. There's often situations where police don't get, helpful statements that allow them to determine what happened, or eyewitnesses are often in conflict. And so in those circumstances, they're limited in the amount of information that they have, so that they essentially end up only being able to say that this was likely momentary negligence. It's also important to recognize when it comes to these offenses that there is a big difference between sort of how we feel and emotionally respond to the consequences of bad driving and what our legal system does. And our legal system has to view things objectively. We can't characterize something as criminal conduct just because the outcome of somebody's actions produced a tragic result. The law recognizes with this distinction between the criminal charge of dangerous operation of a motor vehicle and the motor vehicle charge of careless driving or driving without due care and attention, that there accidents happen, and accidents can happen that have awful consequences, but that does not mean that a crime was committed. And we can't sort of tar and feather and get out our pitchforks to try and punish people because we are hurt by the results of a situation.
Yeah, that makes perfect sense. And I think you said in your video too, in the caption, maybe the law divorcing itself from the emotion. That's a huge one here and what we have to try to understand. That's great. And it leads us into our next question. Obviously, the victims' families are devastated by this. There's a major response in the community of anger and stuff like that. And even I think the opposition party in BC was pushing to get these charges upgraded. There's been a letter writing campaign, all this stuff. People want these charges upgraded. What is the likelihood of that happening, you think? And has it ever happened in BC that you know of, or Canada?
I don't know of any letter writing campaigns that have ever led to
Yeah.
charges being upgraded, because when a determination is made about whether to lay a charge, what happens is the police gather all of the evidence. They don't make the determination. They get the evidence and they make a recommendation to Crown prosecutors about what charge they think it should be, but they're not lawyers, they're not legal scholars. Crown prosecutors look at it and they only approve a charge if there is a substantial likelihood that somebody will be convicted. So they are looking looking at it again from that like very objective, in many respects, emotionless standpoint that you have to compartmentalize to do this job, regardless of which side you're on, and just look at it from the law. If we charge this as dangerous operation of a motor vehicle, is there a substantial likelihood that this person will be convicted? And if they're not, they are not allowed to approve a charge. So, letter writing doesn't change the nature of the evidence that was gathered or is available. Campaigns do not change the assessment of whether something is provable in law, and it doesn't change our charge assessment standard overall in this province. I'm always very disturbed when I hear of like political parties trying to put pressure on the Crown to make a different decision as far as what to do with cases. Politicians should be staying out of those types of determinations. The Crown is considered to be a quasi-minister of justice, and they're exercising a very important role that should be free from political interference that is spurred by an emotional response from a community that is very rightly upset at what happened.
Yeah, and I think we saw that with I think Attorney General Sharma in this case. He even said he was going to launch an investigation, and from sounds like from what you're saying, that is not necessarily really appropriate and stuff. She can't upgrade the charges, and they should be staying out of it, I guess. Is that what you're getting at?
Well, I mean, as the Attorney General, she's in a bit of a different spot because
Yeah,
the Attorney General is essentially like the head of the
yeah,
prosecution, the BC Prosecution Services. So she can sort of review or question decisions that were made within the auspices of her office, but she can't change again the fact that if the evidence doesn't reveal a foundation for a substantial likelihood of conviction, they can't proceed with a criminal charge.
yeah. Makes sense. Fair enough. Awesome. Yeah. So then a next question is so the person has pled guilty of the Motor Vehicle Act charges, and they're due to be sentenced in April. This it's been pushed back quite a few times, I guess technically or whatever. Um, what do you expect the punishment will be for the Motor Vehicle Act charges? I know that 6 months jail time's an option, but that's probably unlikely from what I've heard. Yeah.
That is unlikely. So the maximum penalty that's available for driving without due care and detention is a $2,000 fine and 6 months jail. There's only been one case of which I'm aware where somebody got jail for driving without due care and detention. It was a very unusual case, not sort of your norm. In the range of sentences. Typically, what you'll see is a sentence that includes a fine and sometimes a driving prohibition. And the real determination is, every case is going to involve a fine because a fine is mandatory, minimum fine of $100, which, is no reflection of the value of any life. The fine is meant to fulfill the purposes of sentencing. So denunciation, deterrence, both specific and general, promoting a sense of responsibility in the offender, and rehabilitation. You can't give a fine to somebody that's beyond their means to pay. So all of those things are going to be taken into consideration in assessing the appropriate fine. But typically for this offense, you're seeing fines in the range of 1,000 to 1,500 being the most common fine that's issued. And then the court grapples with whether or not to issue a driving prohibition. And generally speaking, driving prohibitions are only ordered by the court in situations where there is some level of intentional conduct that led to the accident, that, perhaps didn't rise to criminal intentional conduct, but still did represent more of a departure from the norms of negligence, or and this is more common, where people have a bad driving record. If you're a bad driver, the need for specific deterrence and denunciation is higher because you've demonstrated that you can't follow the rules of the road. And now we're seeing the natural consequences of you not being deterred by everything else that's happened up until this point. So, but honestly, driving prohibitions are pretty rare for driving without due care offenses unless they are bad driving.
Okay, yeah, that makes sense. And then, yeah, so kind of the second part of that question, you say that they're going to look at the driving record of the accused and make a decision based on that. It is public knowledge that the accused has a criminal record for non-driving related offenses. People are wondering, will that all be taken into consideration? I think
Not
it was all
really. I
charges.
mean, yeah, what happens in a sentencing is the Crown would likely lead the evidence of the criminal record for
Yeah.
the judge, but the judge determines the weight to be given to it in the sentencing process. And the absence of a criminal record is a neutral factor. It's not mitigating and it's not aggravating. The existence of a criminal record can be an aggravating factor, but where it's unrelated to the offense, it generally is given little weight, if any, as an aggravating factor because it doesn't suggest a propensity to engage in that type of conduct in the future. It might suggest, like a general propensity to engage in lawlessness, but, even then there's limited weight that you can draw from that.
Makes sense, makes sense. Awesome. So yeah, the next kind of question and topic I'd like to discuss is no fault and stuff like that, ICBC. So yeah, the question is there's no criminal charges here or any criminal convictions. Will the victims' families and the victims, some of them are severely paralyzed and stuff, lifelong challenges they're gonna have. What's the compensation gonna look like? Can they sue for damages? What are they gonna get, do you think, out of this?
There's no lawsuit that can be brought in British Columbia flowing from injuries sustained in a motor vehicle accident unless a person is convicted of a criminal offense.
Okay.
So they have no right to sue under the no-fault regime. What ICBC will do is essentially pay for their care, but you don't get under no fault, you also don't get any compensation for pain and suffering, which is what most people think about. When you think about suing and getting compensation for an accident, we all go, yeah, you're going to get your cost of your future care. You're going to get compensation for all your out-of-pocket expenses for your massage therapy or your physio or the equipment you had to buy. That's usually not very debatable. What is debatable and what often results in the bigger dollar figures is this compensation for pain and suffering, which is just out. There's no more compensation for that. And the other thing that is compensated for is your lost income or your lost wages. But under no fault, ICBC does a more truncated consideration of your lost income. You're expected to exhaust all of your sick leave, all of your disability time. Everything is meant to be exhausted before ICBC kicks in, and then they only pay a percentage of what your actual salary would have been until you're able to work again, or if you're never able to work again forever.
And
The,
these were students as well, right? So
yeah.
they have a part-time job, but so they might not be looking at a big payout at all for anything, is what you're saying, I guess.
Yeah, like back in the day when you used to be able to sue for a motor vehicle accident, if you were a student and your plan was to go to medical school and you were getting good grades and it was, reasonably likely that you could get into medical school, the court would do a calculation. They would get expert evidence and do a calculation of what you would earn over your lifetime if you were prevented from ever being in that career again. Like if you had, became a quadriplegic. Or you sustained a traumatic brain injury or something like that. And they would calculate what your income would have been for your entire life, what you lost out on, and then award you that. So you might get, cases in the millions of dollars for people who had plans or were starting their careers in, professions that have very high salaries, lawyers, doctors, accountants, that type of thing. And then you'd get all of this money for that. But with no fault, there's not the same analysis of how much you're out in the future because you're not entitled really to the speculative of what you might have achieved.
Yeah, that makes sense. Yeah. So yeah, kind of the goal of no fault, I guess. This is, I guess, more of a political question, but what is the goal of no fault? And if you can't sue for pain and suffering, why do we have no fault in BC? Like it's
Do you want the official answer or do you want the answer that I think is the real reason? Because there's
uh
two different answers.
let's go with the real reason. You're the expert and an expert opinion. So yeah, what do you think's the
Yeah.
real reason?
Money. The
Money.
government
Yeah.
wanted to save money, and David Eby doesn't like lawyers, despite the fact that he is one. He seems to be very personally offended by the fact that ICBC lawyers, people who were getting people compensation in their motor vehicle claims, were being paid well for the work that they did. They did good work. They got paid well for their good work,
Yeah.
as one would expect to be. But he seemed to be very upset by that, and he didn't want lawyers to be making a lot of money. He also wanted ICBC to save a ton of money. So how do you accomplish both of those goals at once? Create a no-fault system.
Yeah. And I think the appeal to that, they said it's lower rates for us as British Columbians. Is it lower
How
rates?
how much have your rates gone down? My rates have gone down, what, like maybe I think my last insurance, it was down like 200 from the year before,
Yeah,
but I'm
like
still paying thousands for every year. Like this is not,
exactly.
it's not a savings caught
Yeah,
program.
it's
Sorry.
crazy. Mine might have gone down. Yeah, I'm zero at-fault accidents, class five driver, and I think it went down like maybe $50 last year or something. It was
Yeah,
insane.
it's,
Yeah,
unless
yeah,
your rates are meaningfully going to change, people don't really, experience the benefit of that. And everybody got their what, $7 ICBC rebate or
yeah,
something.
something like
Cost
that.
more
Check.
money to print the checks than it did to put back in people's pockets.
Yeah, exactly. Awesome. So yeah, so then the next question, we're kind of going back to the incident here. This is more of a personal question, a legal expert question. Is the standard, in your opinion, for a marked departure too high? Is the standard to convict criminally for something like this too high? Should it be lowered? Are we being unfair to people, do you think? What the victims, what do you think?
I don't think we're being unfair to people. If anything, I actually think what the law defines as a marked departure is too low. Like it's very easy to be convicted of dangerous operation if the evidence is there. There's a very well-known case that went all the way to the Supreme Court of Canada of a person who sped up to make a yellow light to 140 kilometers an hour while going through an intersection in a 50 zone and T-boned a doctor who was turning left, killing him. And the court said, yeah, speed alone can be dangerous driving if that speed is a marked departure in the context of everything. You see people charged with dangerous driving for just like missing that the light is red. Like I have done things in my driving completely inadvertently that would amount to dangerous operation. And that's scary that people can face a criminal charge for something that is just a simple mistake. Like we shouldn't have a legal system that works that way. And I think when we look at dangerous operation and suggest that it is sort of too low in a marked departure, we are again approaching the law from our perspective of wanting the criminal justice system to address the sort of consequences more than it addresses the moral blameworthiness of a person. And that's really what criminal law is looking at. What is your level of moral blameworthiness, regardless of the outcome of what happened? And we should be very careful not to conflate moral blameworthiness with the outcome of some type of unlawful act.
Yeah, that makes sense. And I think like what we've been seeing a lot of is people saying, "Oh, this person should be in jail for the rest of their life." I think it's important to think what's jail going to accomplish, right? What are we going to accomplish by punishing too harshly is kind of what you're saying as well. That's important to think when we maybe help process some of these charges, I guess. Yeah.
Yeah,
Awesome. All right. Well, I think that sums it up. Thank you so much for this. Yeah,
no
if you have
problem.
anything else to add, but I think we're good. Yeah.
Okay, perfect. Well, thank you so much for having me.
Yeah, and I'm sure if you're available, I'll use you again for further projects or anything. And yeah,
Anytime.
if I get a speeding ticket, I'm gonna call you.
Don't get a speeding ticket,
I,
please.
trust me, all of us in this police class, we're trying to be police officers. You can't have speeding tickets if you're gonna want to be a
Yeah.
police officer. All right. Thank you so much, Kyla. You have a great day.
Thank you. You too.
Bye bye.